Hague Convention on Protection of Children of 1918 and 1996. Unfortunately, Hans van Loon has not finished yet. He's now in a parallel meeting. It is the Hague presentation, and he's going to join us in a couple of minutes. He's one of our major speakers, and I'm happy to introduce other speakers who are here with us. Kook Min-soo, Vice Minister of the Minister of Justice of the Republic of Korea. Kook Min-soo. Mr. Kook. Maria Snezhko, head of the Department of International Private Law, of the Department of International Private Law and International Legal Support, Ministry of Justice, Ukraine. Then Mr. Andrei Chernov, Chairman of the Council, a Non-Commercial Partnership Professional Mediators Alliance. And when Hans van Loon joins us, we'll also listen to his opinions on this. Speaking about agreements and some universal mechanisms on an international level that regulate relations in the area of children's and parents' rights all over the world, we can say that currently there are more and more families with parents from different countries, and only this year in Russia we had about 157,000 of marriages like that, and people from 150 countries married people from the Russian Federation, and about 135,000 marriages were with representatives of the countries near Russia. And the Office of the Ombudsman on the Rights of Children permanently receives various applications and requests in relation to various cases when relations between parents in such families need to be regulated. And currently we have about 500 applications like that. We try to help everyone, but without a clear legal mechanism, it is very difficult to do. So we, as those who work in the practical area, we evaluate the necessity to have this mechanism, a mechanism that can be developed within the Hague Convention of 1980 and 1996 on the jurisdiction and parental responsibility and measures to protect children. These both conventions have been ratified in Russian Federation, and now we work towards creation of mechanisms of using these conventions so that our regulation fits the Hague Conventions and is in compliance with it. The Ministry of Education and Science is preparing a number of adjustments into all basic legal acts of the Russian Federation that are related with the use of the Hague Conventions in Russia. Both conventions, they are aiming at protection of children from abduction of children, and also aiming at regulation of mechanisms of returning children, then access to children, and also to confirm various international norms. The state and various agencies and bodies that regulate children's rights, property of children, then law applicable to parental responsibility, then enforcement measures, and so on. We believe that ratification of these two conventions by Russia and implementation of the provisions in the Russian legal system will provide for protection of the rights of children in the communication with both parents. Very often we have such cases in Russian courts, and it's very hard to ensure that both parents have equal access rights, especially if a child is taken abroad. And I would like to welcome all of you, and Mr. Parafenchikov. He is the chief judicial warden of Russia, and he is one of our partners, and we have been working with him in close cooperation, and I'm very thankful to this service of judicial wardens, and even our police. They now don't search for children until a court decision is taken. This work is very complicated. It requires regulation, a clear legal outline and algorithms, and when they do this, they definitely do a great job, and you help people you help children who suffer not only from their broken families, but also because children very often are used for blackmail, for vengeance, and these children they suffer unchildish feelings. The 1996 convention, I remind you, was ratified in line with the federal law on the 5th of May in 2012, and it will become effective as of the 1st of June 2013, and the 1st of June is an International Day of Protection of Children. So this is very symbolical. So this means that starting from June, children's rights will be protected better. And the subject of these conventions, the right of the family and the child for protection, and the obligation of parents to take care of children. Basic European documents are structured in such a way that they always speak about children's rights and children's rights for protection, and we will never see parents' rights mentioned, and this is very important to mention. And in view of all these recent laws, American parents cannot take children from Russia, and people say that, oh, these parents were deprived of their right to have a child. But here it is stressed the other way around. Children have the right to parents, not the other way around. 1980 convention has been ratified by 86 countries, and the majority of the Baltic countries and CIS countries, Lithuania, Moldova, Turkmenistan, Uzbekistan, Estonia, and others. And I would like to say that our Ukrainian colleagues from 1996, they have been implementing the Hague Convention in their territory. That is why it will be very interesting to listen what Maria Snezhko from Ukraine can tell us about this. She's been working in this area for more than 6 years. This is interesting because for us, sometimes it is very difficult to interpret European norms and even to have them explained, because there is a difference in mentality and different cultural differences, and definitely Ukraine is a country and people which are very close to us historically and culturally, and we are very much interested in your experience. So I would like to change the order slightly, and I would like to give the floor to you first. And let's say 10-12 minutes for each speaker. Thank you very much. Thank you very much for your introduction. And it's a surprise to me that I am supposed to speak in the beginning. Yes, I would like to share with you our experience and as the Ministry of Justice, the central body implementing the convention. represent this ministry, and I would like to tell you about various issues that we face in Ukraine, both in terms of understanding and in the regulatory basis. Yes, we have been implementing this convention from 2006, and it is together with other 62 member states. And we, as I said, the Ministry of Justice, we are the central body that performs this function by itself and through its territorial borders. Our system involves various local structures, but we operate only through regional units. There are altogether 27 territorial units of the Ministry of Justice, and they are our colleagues. And if our central body within the ministry has 4 people, and if you add at least 27 people in regions, you will get a team that works towards implementation of the Hague Convention. If we speak about its implementation, there was a governmental decision taken in 2006 that determined the authorities and mandates of all bodies in this area. And we work together with the police and the child care institutions, and sometimes the Ministry of Foreign Affairs, sometimes the Interpol and Ministry of Education and Science, and those who actually execute the decisions. In 2009, there were some adjustments in the procedures because the practice demonstrated that there were some gaps that were filled. And about the number of cases, about 200 applications have been processed, and about 30 are under consideration now. And as for the number of these applications, they are mainly incoming, 140 income and 60 outgoing. And the majority of applications, this is a request to return a child. And 70% of all applications, this is. So about 70% to return a child who is now in Ukraine, about 70% the other way around. Speaking about an average applicant, so speaking about children that parents would like to take somewhere else, outside Ukraine, usually these applicants are fathers, foreign citizens, although in the convention they don't speak about citizenship, but of course it is an important factor. So a mother usually is the person who abducts the child, and she is supposed to return to the country of permanent living. And when a child needs to be returned to Ukraine, usually a father is a citizen of Ukraine, and a child is abducted by a mother who left the country. Maybe she married for the second time, sometimes other conditions. So this is an average situation, but of course every single case is quite different. I'm not going to speak about our everyday work in terms of outgoing applications. We prepare a package of documents, and we try to be in contact with the applicant. This is a standard thing, but I'm going to speak more about incoming applications. We coordinate with a whole range of executive bodies that and they execute some procedures that we establish. For example, the police, or when information about where a child lives is necessary, and so this is done by child care bodies. Speaking about speaking about applications, this is a preparation stage. Okay, we identify where this child lives. Then we talk to a parent. If it cannot be resolved, then we apply to court. We file a case, and this is done through our territorial bodies, and we represent the interests of the applicant in court. Before 2009, such cases were analyzed in all types of courts, but in 2009, following a recommendation of the Hague Convention, changes were introduced into the civil code, and this was about the concentration of jurisdiction. And now 27 regional courts, so they are the first level courts in regions. For example, if a child in Zaporozhye region, whatever town of this region, then the court will be in the town of Zaporozhye. So that will be Ordzhonikidze district court, where we have our regional body. We are aware that a parent will have to travel there, but maybe this person is a violator.
So we don't feel it necessary to make life easier for them. All the first instance hearings are within the civil process, and there can be appeals or cassations. In fact, this has had a positive impact on the review of the cases and the duration of proceedings, because newer judges, of course, take longer time than the more experienced judges. So the requirement of the convention for prompt consideration of cases within 6 weeks has played a key role. Judges have come to take a more serious attitude, and this has had a positive influence as against situations we had previously when it might take them a couple of years to pass a decision. Then appellation may take another 2 months. Cassation is more complicated, and that's a lengthier procedure. So, of course, we are far from the ideal of 6 weeks time, but we've made progress, and this is something we have yet to improve. As regards the terms of appeals, they have been shortened. An appeal is filed within 10 days and a cassation within 30 days, and of course this requires intensive work, especially when preparing an appeal or a cassation complaint. This is labor-intensive process, and we have to meet the deadlines which we try to do. Now, I've mentioned a few difficulties. Some other issues are as follows. Often courts go beyond the scope of the case under review, and they do not always manage to see or assess issues that have to do with residence or guardianship, which is inadmissible. Another point of issue is the shifting of the duty to prove a party's guilt onto the plaintiff, which is not right. Often those courts are guided by emotion rather than the letter of law, and shift the burden onto the plaintiff, which is wrong, of course. And to mention the Ukrainian constitution's provision for the non-extradition of Ukrainian citizens. Sometimes they resort to this provision with regard to children, which is nonsense, of course. And in conclusion, I will touch on the most painful issue, that of law enforcement. And out of the great number of cases, courts considered some 52 and 25 cases were resulted in a decision of non-return of the child. This is done by analogy with other procedures like the separation of the child from a parent, and the service of the court martial, the marshal service have no right to take a child away from the plaintiff, and in fact, or from the other party, but the participants in the conflict resist that in various ways. They may hide themselves. Then this prompts for more court action and applications for children to be placed at special centers and homes. We have cases when court rulings were not implemented, were not enforced for a number of years. For example, in one case since 2009. The European Court has acknowledged that this has in fact resulted in violation of Article 8 of the Human Rights Convention, and of course a compensation was ruled to be paid, but in fact it was a failure to act on the enforcement authorities, and we are planning to change the enforcement mechanism, otherwise the convention is not going to work efficiently. Thank you very much, Maria. That was some very interesting experience. We have understood from your presentation is that Ukrainian ladies are the most energetic. They manage to take their children first. We have been joined by Mr. Hans van Loon, Secretary General of the Hague Conference on Private International Law, and I'm happy to give the floor over to him.
Thank you, Mr. Moderator, and I apologize for being late, but we participated in a big thing downstairs and that took longer than expected, so that's why I'm late. It's not because we slept in or something. So thank you very, very much for inviting us to be with you. This is the second time that I have the privilege of attending the Legal Forum, and I attended the first in 2011, and I've seen it grow in importance, in quality, in diversity, and I'm very impressed. Now, the Hague Conference on Private International Law has, for more than a century, in fact for 120 years, been concerned with the protection under civil law of children at risk in cross-frontier situations. And as you know, during the last part of the 20th century, we saw an opening up of national borders, travel became much more easy, and cultural barriers like the Cold War became obsolete. And that had a lot of advantages, but it also increased risks, and particularly risks for the vulnerable children and the elderly. We've seen also very difficult situations for children and families as a result of natural disasters. Think of the tsunamis, of the earthquakes in Haiti, for instance, displacements as a result of war, civil disturbances. There is an increasing number of disputes over custody and relocation, exponential increase, unfortunately, of parental abduction of children. Used to be mostly abductions by fathers. What we now see is wrongful removals, and sometimes one can question the wrongfulness, but of young children by young mothers who cannot support the new life in the new country with the foreign husband and return to their home country. We've seen important manifestations of cross-border placements of children, inter-country adoption. There are 4 modern Hague Conventions that specifically address the questions of children and family. Modern conventions developed in the last 30 years. And what they all do is they provide practical machinery to enable states which share a common interest in protecting children to cooperate together to do so. The first is the 1980 Child Abduction Convention. The second was the 1993 Hague Inter-Country Adoption Convention. The third is the 1996 Hague Children Convention. And the fourth is the 2007 Convention on the Recovery of Child Support and Other Forms of Family Maintenance. Now, this seminar concentrates particularly on the 1980 and the 1996 Convention, so if I may, I will say a few words about these 2 instruments. And they are not without reason on our list, because Russia recently joined the 1980 Child Abduction Convention. That convention now has almost 90 states parties to it. Another recent state party is Korea to this convention, and Japan is about to ratify it as well. The 96 Convention is later and has about 40 states parties to it. Brief word on the Child Abduction Convention first. The Child Abduction Convention seeks to combat parental child abduction by providing a system of cooperation between central authorities and a rapid procedure for the return of the child to the country's habitual residence. The Convention seeks to secure easy access, but the emphasis is on protecting children from the harmful effects of cross-border removals. And the Convention, and it's important, is based on the presumption that a child should have the right to have contact with both parents, and that therefore a unilateral decision by one of the parents to take the child from the child's habitual residence, from the child's natural environment, is not correct. The parent should do that only in consultation with the other parent or after an order from the court authorizing the parent to do so. Why is that so? As I say, it's important, recognized in the UN Convention on the Rights of the Child, that the child has a right to be in touch, have access to both parents. It's important to ensure continuity in a child's life. It's not good to reward a parent who takes the law in their hand by removing the child unilaterally, to say, okay, that's fine, you stay where you are, because that means honoring the law of the jungle, which we don't want. The Convention is not only a remedy, it also has served as a deterrent. I've heard stories about parents who could no longer support living in a country and intended to move to another country. And they got advice from a lawyer, and the lawyer said, don't go to this, that, or the other country because they are parties to the Child Abduction Convention. If you take the child away unilaterally, the child will be returned. That's no good. So it has worked as a deterrent. Now, another thing that's important to understand, that a return order is not a custody decision. It's simply a measure to re-establish the status quo. And there is express language in the Convention that makes sure that the return order does not have the effect of a custody decision. Why is that so? The theory is, the basis is, the principle is that it is for the court of the habitual, the natural residence of the child to deal with the important decision on custody. That court is best placed to hear witnesses, to consider the situation, and so on. And there's sometimes a misunderstanding about this. Some countries hesitate to return children who are their nationals to the country of habitual residence, and yet there's no reason to discriminate on the basis of nationality. If a Russian child is taken away to Canada unilaterally, then the left behind parent under the Convention has a right to claim the child's return. And the opposite is also true. If a Russian child would be abducted from Canada to Russia unilaterally, then the Russian courts have an obligation to send the child back, even though it has the Russian nationality. Nationality should not play a role. That is very important to remember. Now, the rule is not without exceptions, of course. If the if the left-behind parent has accepted that the child is removed, that parent has no right, of course, is no longer in a position to claim the child back. It may also be that the return of the child would result in a grave risk for the child, physically or psychologically. We don't want that. So that may be a reason for the court to say, no, I won't return the child. And that may then lead the court to take a decision on custody, but not in the first instance. As I said, the Convention is based on the principle of cooperation among states. Each country should set up a central authority, and central authorities are administrative authorities. I believe in the case of Russia, it's the Ministry of Justice, maybe the Ministry of Education. And those central authorities have a duty, first of all, to try to make an amicable, to find an amicable solution. We are not going to stimulate a rush to the court. If a peaceful solution can be found through mediation or otherwise, then that is best. There are cases, more and more so, I believe, where a father claims the return of a child, and he does so not so much because he really insists on the child being returned, but he uses the mechanism of the convention to obtain easy access to the child. In such a case, mediation through central authorities is the way to proceed, because the return of the child would possibly lead to a further relocation and aggravate the tension between the parents, and we don't want that. So mediation is of increasing importance in this field. Brief word, if I may, on the 96th Convention. The 96th Convention is in a way a supplement to the 1980 Convention, and I mentioned this convention with special pleasure because in a few days' time, on the 1st of June, this convention will enter into force for the Russian Federation, which is a huge step forward. It's of tremendous importance, and I want to commend Russia for this next step in the process of international child protection. This convention has a very wide field. It deals with the issue of jurisdiction of the courts. Which court in an international situation has the competence to deal with a question of custody, of parental responsibility, of taking a measure to protect the child or the child's property. That's one piece of the puzzle. The second chapter deals with applicable law, which law should be applied. Usually that's the law of the court itself, but in exceptional cases that may be another law. There should be of parental responsibility. Recognition and enforcement of decisions is the third chapter, very important. It's of no use to have a decision, to get a decision in one country while it is not recognized in another state. And that also applies to short-term decisions. And finally, there is a chapter on cooperation. So the broad issues with which the convention deals are parental disputes over custody and contact. The convention reinforces the 1980 convention. The 1980 convention, as I mentioned, Child Abduction Convention, provides a return mechanism, but it doesn't define itself which court has competence to deal with matters, and that is what the 96 Convention does. So the 96 and the 1980 are complementing each other. The convention can be very useful in the case of unaccompanied children, refugee children. There is a provision that gives competence to courts in the case of refugee children who flee to another country, and this is based on our experience in the Yugoslav war. I visited myself a few countries there in those days, and we noted that there were children from Bosnia-Herzegovina, for instance, who fled to Croatia, and there were issues over appointing a guardian or something, and the Croatian authorities said we cannot do this because these children are from a foreign country, they have no habitual residence, I cannot deal with it. So there is a specific provision now in this convention that gives competence to courts to take a decision on such matters, to in fact require the Croatian courts to take a measure of protection of those children. And then there are provisions on cross-border placements of children short of adoption, like foster care. So it's an integrated system, it's an inclusive system, and we will see in the near future, when the convention enters into force, that it will bring relief in many, many cases between Russia, for instance, and the EU, because almost all European Union countries also now are parties to that convention. As in all cases of our conventions, we do not just produce the treaties, but we also want to make sure that they function properly. So we will organize review meetings from time to time. We've produced a good practice guide, stimulating best practices, a database electronically accessible to everyone on case law, and we will certainly also be at the disposal of the Russian government with the implementation, to help with the implementation of this instrument. Thank you.
Thank you very much, Mr. Van Loon. Спасибо большое.
Thank you, Mr. Van Loon. Thank you very much. Your detailed description of these conventions help us how they work, and an amicable resolution of such cases is extremely important, and very often we forget. Very often we forget that a judge needs not only to consider a case thoroughly in line with the law and take an appropriate decision, but it should be also a fair and just decision. And of course, an amicable resolution is the best thing in such cases, because when we speak about rights of children, everybody should try to reach a compromise. First of all, parents of a child, for the sake of the future, their children. Unfortunately, it doesn't happen all the time, but it's our task, the task of all lawyers, to help courts to reach such amicable resolutions. And we need to learn not how to act in court, but how to resolve cases amicably. And now I would like to give the floor to Andrei Chernov, who is a specialist in the area of mediation. Mediation, first of all, in family disputes. Good morning, dear colleagues. I would like to thank for organizers of this roundtable discussion for the invitation to take part in it. And I would like to talk about this institution of mediation and the role of this mechanism. I represent the Alliance of Professional Mediators. It is a non-commercial partnership. It was established in 2011, and we have experience of regulation, resolution of property cases, and access to child and communication with a child. Our experience and the use of mediation in Russia in general is not very rich, but we are at the very beginning of a big way. In the beginning, we need to come over various problems and difficulties. The mediation instrument of alternative dispute resolution is well established all over the world, but the opinion of Russian specialists and law enforcement agencies is twofold. On the one hand, they believe that, it will be helpful, and others believe that, no, it is absolutely useless. Mediation in Russia does not have a long history. And using mediation as an independent mechanism for a resolution was established by federal law, and it is effective as of 1st of January 2011. That was a precedent for mediation in Russia. It's doubtless that using mediation is a step forward in a development of civil relations in Russia. And although these instruments are very important, and I mentioned the law that established it as a lawful measure. At the same time, we see that it isn't used very often. This can be explained by a number of limitations. For example, underdeveloped legal basis in this area, then the lack of initiatives by those bodies that can initiate mediation mechanisms, then authorities don't participate in this, and finally there's no information And we should share this information. People should know that there is an alternative way of conflict resolution. So this can be done not only in court, but this can be done amicably. The absence of mediation in Russia can be explained because it is very cheap to file a lawsuit. And mediation agreement has a quite a weak status. It cannot be enforced. And also one of the barriers is the lack of information. So both parties don't know how this can be used. The Convention on Civil Aspects, so the Hague Convention of 1980 was ratified. And later the Convention on Enforcement and Cooperation and Parental Responsibility of 1996. And international experience demonstrates that when there is a conflict between parents and when a child needs to be returned to their habitual area of living, mediation can be used. Mediation can be effective when parents need to determine the scheme of their communication. And definitely that the main purpose of mediation in family conflicts needs to be used because there's a positive influence for both parents and children. It is necessary to improve the mediation institution generally, and we need to improve qualifications of people who are involved in it. A number of measures have been taken that regulate mediation procedures. For example, there's a draft law on making adjustments into certain normative acts. This draft was prepared by the arbitration court, and now this draft is under consideration by the State Duma. And one of the mechanisms included into this is the institution of amicable resolution in the arbitration code of the Russian Federation. And this concerns judicial sphere. So, currently, it is only in the business and economic area, but family and parental rights of children are not mentioned there. The current regulation and various norms which do not establish an integrated system prevent from effective use of mediation. And there is a great capacity of this mechanism. And definitely there's some regulated case will be reinforced by various amicable resolution procedures, and this will be effective for both courts and parties involved. The amicable resolution will help to reduce the number of lawsuits and also will improve the judicial function. And that was included into the document issued in 1986, international document on easement of court burden. And a number of adjustments proposed by the arbitration court are evaluated and assessed in different ways by the professional community. But I should stress that mediation is extremely important and significant, and practice shows that mediation can be used for conflict resolution. And in Russia, we see that economic conflicts are more often resolved by mediation rather than various cases where children's rights are considered. The amicable resolution procedures have been used only in 11 lawsuits. This number is not very big, and if we speak about families and parental rights, this number is even less. And there's very often some there are negative feelings and various contradictory claims of the children. They don't want to hear anything from a mediator or whoever else. And speaking about mediation, this sphere of family relations is unfortunately not very attractive, if I may say so, and this is done not through some charity initiatives, but it is just some private initiative, and this is so the engine of mediation mechanisms. So this all over the world is used in various economic processes, but the social area of mediation that we represent within the convention, Hague Convention of 1980. Usually, these initiatives are financed on a grant basis. Of course, the claim of one parent is not enough. Yeah, it is important to locate where the child is, and an important aspect is that parents have to pay to mediators. I can give you an example. A non-commercial partnership I represent, in the recent years, we have had several cases when we used this mediation procedures, and only in 2 cases, and within our alliance, there's about 13 cases, and 13 cases of family mediations, and positive results were reached only in 2 cases. So this family mediation is sometimes have a speculative nature. For people are not quite honest in relations among each other, and very often mediation is used to delay decisions, and in court probably these cases can be resolved faster. In 2011, our organization worked together with the Ministry of Education, that is a central body in this area in the Russian Federation, and it is responsible for implementation of the Child Abduction Convention. And we unfortunately should say that none of the cases with children abduction haven't been successfully completed using mediation. Currently, this can be explained by a number of factors, including those I mentioned above. But we will continue our work and will continue development of the strategy that will help us to make it effective. And the convention will become effective in Russia, and we are absolutely sure that mediation should be involved in its implementation. According to the data of the Ministry of Education, a draft federal law on introducing changes into various normative acts will be issued, and this draft law will support the convention and will support implementation of the convention. It is planned that there will be measures that are related to investigation where children are, those who were taken to Russia or outside Russia by one parent. Also, there will be specific procedures and time needed for them, and also there'll be specific measures for returning children after a court decision is taken. We believe that this draft law will be correcting the norms that exist in the regulatory basis, and the professional community of mediators is interested in expansion of the use of mediation in protection of the rights of children, and we hope that this law, this draft law, will include a mediation as an element in dispute resolution, especially when we speak about cross-border cases. And this roundtable that deals with the implementation of the convention is definitely very helpful because it allows all of us interested in this area to share experience and ideas, and our organization is ready to participate in this process. Thank you very much for your attention. Thank you, Andrei Viktorovich. We do realize that to become a mediator and to work in this, you need only to believe in law and justice, but you need to be an enthusiast as well, because the practice you have outlined shows that it is very hard to move our people towards amicable resolution. I also did a lot in this area. I studied it in the United States, and I have a course in the Moscow University, and I call it the science of making peaceful decisions.
Still, I believe that the future belongs to it, because the entire civilized world is following the path of alternative out-of-court procedures. It is of great importance for Russia to be part of these two conventions, because in the wake of the disintegration of the Soviet Union, many treaties, over 72 treaties concluded by the Soviet Union on bilateral assistance in civil cases, family cases, and other such cases. They went out of force, and we were not able to continue many of them, so it has created difficulties for us to deal with parental disputes in mixed marriages. We know these cases. They are still debated vividly in the media and at the level of government authorities in our dealings with Finland, France, Norway. And mechanisms are very difficult to develop in the absence of such agreements. We have been able to set up a commission with France, and we have been able to reduce political arguments to the level of legal arguments. This commission is also the prototype of some mediator of the future. And the first precedent has been set by the Helsinki court when the judge referred directly to Russia's ratification of the Hague Convention when making a ruling on the destiny of two small children belonging to a Russian mother. We met with our Finnish colleagues yesterday, and I feel the path will be difficult, but we are on the right path. So we will be able to move forward a number of disputes that spoil our relations with some countries, because failing a legal mechanism, all these issues are dealt with too emotionally and politically. And now I'd like to call on Mr. Cook Min Soo. Korea did Korea ratify the convention? Has it ratified the convention, or has it only joined it? Please mention this in your presentation. Now I call on Vice Minister of the Ministry of Justice, Republic of Korea, Cook Min Soo.
Thank you for your kind introduction. Distinguished guests, I am delighted to meet you at this prestigious forum. It is my great honor to have this opportunity to speak about the Republic of Korea's accession to the Convention on the civil aspect of international child abduction and the progress we have made so far at this momentous occasion to Secretary General Hans Van Roon and experts from around the world. This convention ensures that the protection of the human rights of a child is of paramount importance by pursuing the prompt return of children who are wrongfully removed overseas. It is in this spirit that the convention has been highly regarded as one of the most important international conventions that have contributed to the enhancement of children's rights. The protection of children's rights has become another serious social issue in the Republic of Korea, as the country has begun seeing a growing number of multicultural families within its territory and the subsequently increasing rate of divorce among international couples. As of 2011, the international marriage rate accounted for 9.3% of Korea's total marriage, and the divorce rate was 12.6%. There have been many cases where a child has been illegally taken overseas by a parent when the marriage broke up, but the child's whereabouts could not be even identified. To address this issue and protect children's human rights, the Republic of Korea has acceded to the convention as its 89th member state, following this forum's host, Russia. Right after the act concerning implementation of the Hague Convention, submitted by the Ministry of Justice, passed the National Assembly in November 2012, the Minister of Foreign Affairs deposited the nation's instrument of accession, eventually allowing the Convention and its implementing act to take effect on March 1, 2013. Korea's implementing act aims to protect children's rights and interests and reaffirms the purpose of the preamble of the Convention. The implementing act provides a methodical administrative system. It designates the Ministry of Justice as the central authority of Korea to be in charge of providing administrative supports described in the Convention, enabling it to request cooperation from relevant organizations if necessary. Furthermore, the Act emphasizes the speedy trial process, one of the Convention's priorities. It stipulates that the authorities shall act expeditiously in proceedings for the return of children, and that the court shall notify reasons for any delay in trial. To make sure the child abduction cases are dealt with more professionally, the Act concentrates the jurisdiction over Convention applicable cases within the Seoul Family Court. The Act enables the court to issue an order of performance in order to improve the court's execution power, and at the same time has established the child return procedure to impose penalties such as the fine and detention of the violation of the court's order. The Ministry of Justice has fully incorporated into the Act the main idea of the Hague Convention on Private International Law's Guide to Good Practice. Not only has our ministry enacted the Act, but it also plans to recruit human resources who will work exclusively on issues regarding the Convention in order to fully implement it. In recognition of these efforts, the Supreme Court of Oklahoma allowed the enforcement of a Korean court ruling on a child return case late last year, immediately after Korea's accession to the Convention. As we are all aware, no single country can successfully implement the Convention alone. To ensure that the Convention comes into successful fruition, we need close cooperation among the central authorities of the contracting member states, as well as each member's well-developed domestic implementation system. The Ministry of Justice of the Republic of Korea, along with the Ministry of Justice and Ministry of Foreign Affairs, is making their utmost efforts to convince the existing members to accept Korea's accession to the Convention. We hope we can provide timely and effective support for appropriate child return in close cooperation with their counterparts. We, as Convention members, welcome nations around the world to join the Convention because it is in everyone's interest to see the spirit of the Convention globally realized. Because the Asia-Pacific region is one of the world's most vibrant areas for human resources exchange and economic cooperation, it is my hope that we see more nations in this part of the world join us in our efforts to support the rights of our children. The Republic of Korea is more than willing to exchange information and share expertise on the accession to and implementation of legislation regarding the Convention with a non-member state that has keen interest in promoting children's human rights. It is my sincere hope that this forum will be an optimum opportunity to form a global legal network among different nations to effectively implement and promote the Convention. I will always keep in mind in this memorable time I have spent with you in St. Petersburg, the historic city adored by the founder of Russia's modern literature, Alexander Pushkin. I love thee, city of Peter's making. I love Sci Harmonies austere. Thank you very much.
Thank you very much. Большое спасибо, господин Кукминцу.
Thank you very much. Of course, the efficiency of the convention increases as the number of its members grows, and I suggest that we entrust Mr. Kuk-min-soo and other representatives of the Republic of Korea to work with their neighbors, I mean Japan and the People's Republic of China, for them also to become members of the Convention, and we will continue our own cooperation with these countries to expand the number of participants in the Convention. And of course, when talking about the advantages given by the 1980 Convention is that it enables a very solid and ramified infrastructure of relationships between parents and children, and it's not only gender balanced and neutral, and also just and fair, which is very important, because we as lawyers know perfectly well that law should always be fair and just. And I would like to thank the participants in this round table. We have some 15 minutes left. If you do not mind, we could take questions, but I know that Mr. Hans van Loon is in a hurry. He is very popular, not only at this forum, but also as the Secretary General of the Hague Conference. But it's okay, you can ask your questions. Thank you very much. I am Alexei Dronov, Vice Director of the Legal Department of the Russian Ministry of Foreign Affairs. In the first place, permit me to sincerely thank you, Mr. Astakov, and our colleagues and guests. May I make a few important remarks. One remark is that globalization is not only taking place in the economy, but also in family relationships, and we are witnessing the increasing role of private international law. And of principal significance here is the issue of legal certainty. In conditions of globalization, this can only be assured by participating in conventions. In this context, as a member of the Russian delegation to the Council on General Issues and Policies, whose meeting was held in April in The Hague, that we need to step up our activities by way of joining the Hague Conventions. The fact that Russia's accession to the 1980 Convention was perceived very positively, well, is really true, and I can tell you more. The issues of children are becoming key issues in the activities of the Hague Conference, and Russia used to play a key role in that, and it is especially important and it's especially appropriate to mention that in the year of the Netherlands in Russia and Russian year in the Netherlands. I'm mentioning this also because there are a number of other important instruments. The 2007 convention, our participation in it is limited, but this has been discussed actively during the latest council meeting. And as regards the choice of court, we have yet to do a lot with our colleagues from the Ministry of Justice and the Ministry of Education. We clearly realize that the issue of children's rights is a priority issue for us, and we're in constant interaction with you, and we would like this interaction to help our bodies of authority to use these important international instruments. So there's a need for cooperation between the competent Russian authorities and the Hague Conference on private international law. We can use the information center that has been set up at the Moscow Institute of International Relations. And what is of utmost importance here is that we need to use various levers to raise awareness there is a need for higher awareness raising among the public and government authorities of the convention. There also exist a number of technical issues. The official site of the Russian government still makes no mention of the central authority that has been appointed under the convention, because the decision has been made, and we have talked about that with you, Mr. Van Loon, that Russia has taken this decision. I'm under the impression, in the wake of the Council, that one very important area is the development of regional cooperation based on the Hague Conference standards. And since we are having guests from our closest neighbors, I think we need to develop regional cooperation more actively. Regional cooperation, which would be part of the broader cooperation in the human rights field. So this is what I was going to say. But back to the convention. There's a very interesting process going on now. Russia is considering accession to those multilateral conventions it has not been part of previously, and the president of the government has decreed that, and this is a good chance for us to look at the Hague Conventions.
Thank you very much. It was a speech from the ministry, from representative of the Ministry of Internal Affairs.
At Mr. Dronov's intervention, and he continues expressing his support, as he also did at the council meeting in April. We were very honored by your presence, Mr. Dronov, at the council meeting. And you're absolutely right. If we think through globalization and we only look at the economic side of things, we are seeing only half of what's going on. When you talk about investments and trade, then that always involves people and families, and you cannot separate investment from family law issues. So it is really a sign of realism and not just idealism, I think, to be aware that globalization requires us to cooperate not just in the economic sphere, but in all spheres, including the social sphere and this area. Russia is to be commended for its enormous efforts, as we should thank Korea for what it has done, and we see a sudden rise in effective cooperation at the international level, which is ultimately in the interest of all of us. Because if there's one area of the world where there is uncertainty, it will reflect badly on us all. There's still work to be done. Regional cooperation is important, we recognize that. At the same time, the force of globalization is so overwhelming that regional efforts had their limits, and this child abduction, for instance, is a clear example of something that happens among all countries. You can't invent the strange situations that we have lived through. So it's a step, regional cooperation as part of a global process. Thank you so much, Mr. Journal.
Спасибо. Пожалуйста. Представляйтесь, пожалуйста.
Thank you. Could you introduce yourself, please?
Tom McNally. I'm the Deputy Justice Minister for the United Kingdom. We're about halfway through the parliamentary process of a new family law in Britain, and I've found this discussion extremely helpful in that process. Just 2 points. One, part of what we're trying to do is to get the buy-in from the judiciary for their responsibility to make sure that cases are managed quickly and efficiently, because 2 years in the life of a child is an enormous delay. And so we're trying to get a uniformity and an efficiency, which we have got into buy-in from our judiciary. But the other point is that we're also trying to encourage mediation, as not, as the speaker rightly said, not as the solution to everything, the silver bullet, but as a major contribution. But in that, I think it's going to be important that both nationally and internationally we promote recognised standards of mediation, that it's not just somebody screwing a plate on their door saying that they're a mediator. If it's going to get the recognition it deserves, we've got to promote the standards that will give confidence in mediation.
Thank you very much. Господин заместитель министра юстиции.
Thank you very much, Deputy Minister of Justice. Yeah, it's an interesting news. Even in the United Kingdom, they are going to change family law. So that's a good demonstration that, yeah, so children are a great part, and we need to speak about it when we speak about globalization. This roundtable discussion has been very useful. Thank you very much. And this city is not only the city of Pushkin, but also of Dostoevsky, and we all know his quote that he said that nothing can be compared with a tear of a child. And speaking about globalization, I'm sure you'd say, I would never love humanity if there were not children. Thank you very much.